Mahima, you can start.
जी शुरू कर सकते हैं।
ठीक है सर. Humaid, are you ready?
Yes, ma'am.
Please start. Mahima, you can start. Humaid, start please.
Okay. Good morning, everyone. I, Hamid Duria, member of Knowledge Stage, welcome you all to the second International Virtual Conference on Clinical Legal Education, Legal Aid, and Human Rights 2023. For this technical session, we have Dr. Devendra Singh, Chairperson as Department of Law, Punjab University, Chandigarh. Dr. Devendra Singh, a dynamic and competent professional with over 23 years of experience as an academician, proven ability to represent in various arenas of academics, ranging from education to be an author, solid interpersonal and communication skills in building key interpersonal relationships with peer, students, and individuals, highly organized and dedicated with a positive attitude, able to set effective priorities and handle multiple assignments under high pressure with tight deadlines. Sir, Dr. Devendra Singh, sir, I would request you to say a few words. Sir. Devendra sir.
Mac, I think sir has lost the connection. We can start, and maybe when sir will join, we will ask sir to speak at the end. Will that be fine?
Right. Sir is here though, but we can start. Humaid, we can start with. You can go on with it.
Okay, sir. Okay. Before we proceed further, I would like to clarify that each presenter will have 10 minutes only, and you are all requested to comply within the time limit. All questions will be taken at the end of the session. Your timing will be informed in chat box and will be kept track on the same. Moving on the first presentation by Neha Parveen. The title of the presentation is Clinical Legal Education in the Panorama of Legal Aid and Human Rights and Analysis. I would request Neha Parveen to proceed further.
Just give me a minute.
Praveen ma'am, you are muted.
So, yeah, got it. Okay. Good morning, everyone. My topic for this international conference is on clinical legal education in panorama of the legal aid and homemaker. So as my technical session, in the technical session list, my number is first. So definitely I'm going to start with the definition of the clinical legal education. So firstly, about the definition of this clinical legal education, the definition that is given by Richard Lewis. Richard Lewis has said that CLE, clinical legal education, is essentially a multidisciplined, multi-purpose education which can develop the human resources and idealism needed to strengthen the legal system. He said that the lawyer is a product of such education would be able to contribute to national development and social change in more constructive manner. In the same way, N.R. Madhavan Menon, he said that a learning environment where students identify, research, and apply knowledge thing which replicates at least in part. The word say that like till now the courses is a theoretical one. Whenever the student is getting the theoretical knowledge, it's not working at all. It's not working at all. It's not beneficial for the society at all. So how to construct that? How to construct that theoretical session into the constructive session for the students and the society? It is said that clinical legal education has to be implemented. So for that, we can understand that clinical and legal education is provided different and more pragmatic approach to learning the law. The students can learn through doing. That is called as reflective lawyering. Reflective lawyering, it depends on the experience. It depends on the experience of the students through their own doing and their own working. So for that, Justice Ahmadi Committee, Justice Ahmadi Committee in this 1994 has suggested for implementing four courses. Courses. First one is moot court pre-trial preparation and participation in trial proceedings. Second one is about drafting, pleading, and conveyancing. Third one is on the professional ethics, and fourth paper is on PIL, public interest litigation, lawyers, legal aid, and paralegal services. Regarding this recommendation that is given by Justice Ahmadi Committee of 1994, paper 1, paper 2nd, and paper 3rd, that is implemented, of course, by Bar Council India via by the power that it is having under the Advocate Act 1996. Then regarding the fourth paper, that is a PIL, lawyers, legal aid, and paralegal services, it is not still implemented just because of the technicality. As we know that through the PIL, anyone can sue in the Supreme Court through the PIL, but it is going to increase the complication. So regarding the recommendation that is given by Justice Ahmadi Committee, paper 1st, paper 2nd, and paper 3rd has been implemented yet. Then in 1973, there is one expert committee on the legal aid that proposed the involvement of the law teacher and students in the legal education system and legal justice administration system, involvement of the students as well as law teacher. So according to it, it is said that every action by which legal institutions are sensitized, every legal institution through which the legal institutions and students and the teachers are sensitized to respond to socio-legal problems of the society, that the real society's problem. So whatever was recommended by the expert committee on the legal aid, that was to proposed by the Judiciary Committee on the Legal Aid 1977. In 1981, again, one more committee was there, Committee for Implementation of the Legal Aid Scheme, that insisted that court-oriented programs are not suffice for social justice in India. It is saying that legal aid scheme, about the legal aid scheme, this committee for the implementation of the legal aid scheme, it is saying that court-oriented program, that is mooting and just sitting in the court and seeing the whatever is happening between the advocate and the judge, that's not enough at all. Whatever the caliber of the student is, that also has to be utilized. How to be utilized? By the promotion of the literacy, by organization of the legal aid camp to carry legal aid services to the people to their doorstep. Next is about training the paralegals, and next is about establishing the legal aid clinic. And after that, it is also like Bar Council of India, by this Advocate Act 1961, it has made this mandatory for all of the university, for law university, for all of the law schools to have fundamental clinic which would work with the community to provide basic legal services. To provide the basic legal services. So for that, it is suggested that they should establish their clinic in rural areas, in semi-urban areas, because the problem of the literacy, just because of the illiteracy only, they are not having the access to the justice. So the government is having many schemes at all. Government has given many of the policies for them, but they are not aware of that. So for that, it is saying that it is suggested that they should establish their clinic in the rural and the semi-urban areas. Um, this will help in the protection of the human right, or you can say right of the people as well. So universities may make, so for that universities may make the joint venture for this purpose, for the protection of the right of the people, or you can say to give the advice to the poor people. For that, universities may make joint venture with the district, or you can say talukas, legal services authorities under the National Legal Services Authority Legal Aid Clinic Scheme 2010 and Paralegal Volunteer Scheme 2010. Next is about CLE and human rights perspective. So when we are talking about it, I'm remembering about the statement of the Upendra Bakshi when he said that what do generations signifies? What do generations signifies? So for that, he is giving the answer. Growth in the self-reflection and wisdom and capacity to serve the underprivileged. So unless your caliber, student's caliber, is not utilized for the benefit of the underprivileged, it is not having any use. So how students can get the knowledge about the clinical education program, or you can say how the universities can implement it. So for that, one awareness program is there. Usually they in the event the universities conducted in the far flung areas. Next is about students can be the part of the legal clinic of the university level for the college level, and their this internship program. And this internship program right now, Bar Council of India, through the curriculum, has implemented as mandatory subject, because now internship is counted in the grade system, in the number system. Next is about the legal camps, that universities can conduct the legal camps as well. So it's all about now the students are becoming much more active. So this legal framework, which is itself is given by the Bar Council of India, approved by the Bar Council of India. Students also know that now they are the part of the legal system. Earlier we used to say that the whoever is not qualified as a lawyer cannot represent the court. Obviously they cannot represent the court, but they can give the advice to the poor and the underprivileged person. So now, just because of this legal framework, as right now I told you about the three of the schemes of the Bar Council of India through NALSA and these all 2010, they are very much prone. They know students that they are having at least the right to advise to the people. So they even, just because of this system, they even not hesitate to file the case in the Supreme Court as well, right now I went with one of the case in which regarding the environmental issue, this National Law University of the Pune has filed a case in the Supreme Court on the environmental issue. Regarding other than that, in the National Human Rights Commissions also, they filed many of the case as well. So thank you everyone. I have done my bit. Hello.
Thank you so much, ma'am, for your time. Now we will move to the second presenter, and Divyanshu Rathore and Nitin NC on the topic of clinical legal education, bridging the gap between study and legal practice.
Can you identify the student? Are they in the meeting? If they are not in the meeting, you can call the next presenter.
Okay. So the next presenter is Sailashri S, and its topic is the role of legal aid cells and law clinics in bridging the gap between theory and practice. I would like to call Sailashri.
Is he here? What is the name?
No, she
We
is
can
not.
move on to the next presenter.
The next presenter is Dr. Sailaja Pettigum, and her topic is clinical legal education is sine qua non for both access to justice and legal education. Would like to call Dr. Sailaja Pettigum. Mahak, ma'am.
Yes.
Will you allow a participant to speak as Divyanshu Rathore is present and she wants to speak up upon her topic?
I'm audible to everyone.
Am I audible now?
Yes, sir. You are audible.
Okay. First, good morning to everyone. Myself, Divan Pirada. I'm presenting upon legal education, bridging the gap between study and legal practice. So I'll continue with the introduction first. Clinical legal education, firstly emerged in United States in 1916 to give valuable skill based on instruction to law students while providing legal services to people who are not otherwise affordable. For a law student like me, the academic study of a law and actual practice of its principles seems worlds apart. With our desk piled high with the books, case reports, and legislation, the opportunity to experience and reflect upon the human interaction that underpins legal practices is notably lacking. While good lawyer-client relationships are vital to successful legal practice at present, a law student can obtain their law degree without ever interviewing a client or managing a case file. It was with the paramedics in the mind that in 2022, we embraced the opportunity to be part of a legal internship program in Patna High Court under a law practitioner. The program involved working voluntarily every day for 4 weeks in Patna High Court, as the program was a part of legal practices and conduct courses. The aim of the internship was to explore the legal practitioner's duty to the client, the court, the fellow practitioners. This was primarily achieved through reflection upon our observation of legal practitioner and from our own personal experience of practicing as a law student lawyers. Throughout the program, we observed the client and interviews and court appearances conducted by experienced practitioners. This provides us with a first-hand perspective of the legal system, and we were encouraged to study and critique each practitioner's different style of interview, advocacy, and case management. All students were given the opportunity to develop their own skill through participation in a law clinic. We interviewed client, researched matter, wrote letters of demand and advice, and if required, briefed counsel and prepare a client for their court appearances. At the end of the each day, we wrote a journal entry about our experience. This encouraged us to reflect upon our own skills and ultimately assist in our own development, both as individual and aspiring lawyer. Now I'll continue with what CLR means. Clinical research is a practical approach to learning that prepares law students for an effective practice. If it offers students opportunity to work on a real legal problem and cases, which help them develop their skill and knowledge necessary for the practice of law. In legal research, the students are supervised by qualified lawyers and law professionals. They are given real cases with real problems of various complexities to ascertain facts, analyze legal issues, and suggest solution or remedies to the clients. The process of clinical research involves interviews with the client, researching legal precedent, drafting legal documents, and arguing in the court. Now, I'll continue with the theoretical foundation of clinical research education. Clinical legal education is a form of experimental knowledge that provides law students with the opportunity to engage in a real world legal work under the supervision of experienced attorneys. The theoretical foundation of CLE draws from a number of different legal education perspectives. One important influence of CLE is the social justice perspective, which emphasizes the role of law in promoting equal access to the justice and addressing systematic inequalities. Clinical legal education is often originated towards working with a marginalized and disadvantaged population, such as low-income individuals, immigrants, and prisoners. The social justice perspective is reflected in a type of legal work that students are engaged in through legal programs, which often involves advocacy on the behalf of unrepresented groups. Another important theoretical foundation of CLE is the learn by doing approach to the experimental education. Clinical program provides students with opportunities to apply legal theory and doctrine of real world situations and to develop practical skills such as client interview, case analyze, and legal writing. This hand-on approaches to learn learning is seen as a valuable complement to traditional classroom instructions, allowing students to gain a deeper understanding of a legal system and practical challenges of legal practice. Finally, CLE is also grounded in an ethical and professional standard of legal profession. Clinical programs are designed to foster ethical behavior and professional responsibilities among students and to prepare them for the demands of legal practice. This includes developing a strong understanding of legal ethics and professional norms, as well as learning to work collaboratively and communicate effectively with the clients and other legal professions. Overall, the theoretical foundation of clinical legal education is grounded in a commitment to social justice, a hand-on approach to learning, and a focus on professional ethics and responsibilities. These principles informs the design and implementation of clinical program and help to prepare law students to successfully and fulfilling career in the legal profession. Now, the nexus between the clinical legal research, legal aid, and human rights. Clinical legal research, legal aid, and human rights are interrelated. These three aspects work together to create a justice system that is empirical, free, promote access to justice for all. This article discusses the nexus between clinical legal research, legal aid, and human rights, and how they can be used to provide legal representation on vulnerable population. It explores the challenges faced in the provision of clinical legal research, legal aid, and human rights, and possible situation to overcome these obstacles. Clinical legal research, legal aid are critical tools for the promotion and protection of human rights. These tools have been used by human rights group lawyers to bring about social justice in various countries. Clinical legal research provides law students with hand-on experience and expose them to real legal problems and cases affecting marginalized groups. This training helps students understand the challenges faced by these groups and develop skills required for advocating on their behalf. Clinical legal research also contribute to a body of knowledge on human rights issues, which provides a valuable resource for advocates, lawmakers, and policymakers as well. Legal aid organization collaboration with a legal research committee to provide free legal services to disadvantages the marginalized group. These organizations help individuals and communities enforcing their legal rights, access justice, and hold government accountable for breach of human rights. Now, the challenges in the provision of clinical legal research, legal aid, and human rights. Access to justice is a fundamental right. However, access to legal aid, clinical research, and human rights is a challenge to most marginalized groups. This high cost of legal research and socio-economic factors such as poverty often restricts access to clinical legal research and legal presentation. There are also structural challenges that affect the provision of clinical legal research, legal aid, and human rights. These include a lack of funding, inadequate legal aid policies, and a lack of mechanism to hold the legal practitioner accountable. These structural changes poses a threat to a effective execution of legal aid program and clinical legal research. A possible solution to overcome these challenges is the adoption of pro bono legal services. Pro bono services refers to legal services provided for free or reduced fees. It is a way of ensuring access to legal aid for vulnerable population. Other possible solutions include the advocacy of implementation of legal aid policies and the establishment of mechanisms. Now, I'll go with some examples. Clinical legal research has been used in the various human rights cases around the world. For instance, in South Africa, clinical legal research contributes to a dismantling of apartheid by providing legal support to activists and Organizations challenging the discriminatory laws of regime. India simply programs such as visiting rural areas and providing information on government programs to committee provided tremendous support to local communities in assessing government and justice system. Once a successful program is to conduct by SM Singhal Foundation in the partnership with Jindal Global Law School, which provides year-long training to local villagers and teaches them the functioning of the system and providing them with a tool of monitoring the system. The Jindal Law School, good governance and citizenship participating, clinical support of efforts of the villagers by providing government's training, including through the panel discussing with government officials policy advocacy based on problem. On the other hand, other forms of corruption that villager encounters. The clinical also hosts an annual conference on good governance and citizenship participation, and also provide training to the NGOs and academic institutions. Now I'll conclude myself. Clinical legal research and legal aid are integral to the promotion of protection of human rights. These tools are crucial in challenging discriminatory laws and practicing enforcing laws right and promoting social justice for marginalized and vulnerable groups. Through clinical legal research, law student can obtain hand-on experience in addressing real human right cases and develop the legal and advocacy skills required to promoting human rights. Legal aid organized legal aid organizations complement the efforts of clinical legal research by providing free legal services to individuals and communities who would otherwise not afford them. By bridging gap between clinical legal research, legal aid, and human rights protection, we can continue to support and the fight for justice and uphold the freedom and right of the people. Thank you. Thank you, everyone.
Thank you so much, Divyanshu Rathore, for your presentation. I would I would like to call the next participant, that is Shailesh Kumar Pandey. His topic is initiatives to enhance the functioning of legal aid clinics established in legal educational institutions.
Yeah, thank you so much. I was muted by the host. I guess I am now audible to you and respected member of the chairs. I also want the permission to share the screen if that permission may be granted.
Sure.
Please. So I think my screen is visible, and this is Shailesh Kumar Pandey, and the paper has jointly written by Dr. Balvinder Kaur, who is convener of Pro Bono Club HNLU, and me, Shailesh Kumar Pandey. So the topic is initiatives to enhance the functioning of legal aid clinics established in legal educational institutions. Now, as some of my fellow speakers already pointed out, what are the importance of having these legal aid clinics? I'll not focus much on that. Mostly legal aid clinics are established in the name of pro bono clubs in these legal educational institutions. Now, what is the meaning of pro bono club? It not just includes delivery of the legal aid services, but also includes the methods to enhance the awareness and the methods to create an outreach program for reaching to the masses and awareing and educating them about their legal rights. Now, when we talk about the expectations versus reality, the Bar Council of India and other agencies, they continuously insisted that educational institutions should promote legal aid activities in their college or in their curriculum so that the students can get involved in the process of nation building, and they can get involved in the uh, what you can say that basically they will know about the former part of the law that they will be taught in law schools, and the latter part of the law that they will see and observe in the society. Now, BCI rule is there, which mandates that all the legal educational institutions who have been granted permission under Bar Council of India to go for legal education and to deliver legal education should establish one legal aid clinic. Now, these legal aid clinics, I have worked in legal aid clinic in my UG, and I have also worked as a paralegal volunteer and uh, a resource person in certain awareness programs relating to legal aid. So what I actually feel is that there is a huge gap between the expectations that were somehow put forth and the reality of the legal aid clinics. Now there are some problems that I'll be discussing in next slide. I just want to conclude this slide by stating that legal aid programs should be focused upon the needs of the society, but on observance of various legal aid clinics that have been established by some elite legal educational institutions, except few. We found out that they are most concerned about organizing seminar, workshop, everything. But the massive outreach program and on-ground awareness programs are lacking in their overall planning. Now, I move to the next slide. What are the fundamental challenges for clinical legal aid? Institutional legal aid clinic, it is a typo. So, first of all, operational challenges. Most of the students, when they are in the law school, when they are taken to the field for educating and awareing people and citizens about their right, somehow they don't even get the time to adjust in the local culture, and they feel very uncomfortable in the local conditions because they don't find it very good in terms of facilities. When you go to field, when we went to field, there were a lot of challenges, cultural challenges. Somehow environmental climatic conditions were not that friendly. Going out from the AC classrooms of our NLU, it was not that fine. As well as the students are not that prepared to meet and face the society. Now, organizational challenges are there. Organizational challenge means the challenge within an organization to effectively run legal aid clinics. We have got the process of long file work and extremely delayed chain of command. And that is the reason why continuously the request for going for new awareness campaigns and initiating new programs is delayed at the organizational level. More importantly, the budget is one of the major constraints because there is very limited budget that is devoted for legal aid and awareness activities. So due to this, the effective planning and acquisition of the required gadgets as well as uh, the required facilities is not properly done. Now, academic challenges. Here I want to highlight this. It is not very personal experience of mine, but most of the students who were involved in legal aid activities. First of all, we need to incentivize the legal aid programs participation in terms of some additional grade or at least some certificate of participation. So far, the certificate of participation is mostly given for certain few programs and not for developing something new and something contributing in the field of legal aid and awareness. Just like if I make a YouTube video stating all the local law facts for educating the masses, there is less chance that I'll get a certificate because most of the legal aid clinics don't have these kind of practices to incentivize the new efforts and to incentivize the creativity of the students. Now, collaboration-oriented challenges are there. We know that there are national legal service authorities who are working for National Legal Service, State Legal Service, and District Legal Service Authority who are continuously working for dissemination of legal aid and ensuring legal aid available to all. but the educational institutions are not very comfortable in collaborating with them because they think that some external pressure will be inserted upon them and they don't want to take that pressure. They want to remain independent. They'll do activities as per their convenience and their, what you can say, resources. Now we move to the potential of the institutional legal aid clinics. I have seen what youth can do. Youth is now full of creativity. The creative methods like creation of a multimedia video, creation of some materials that can be circulated amongst the masses, some awareness programs including creative nukkad, poster making. These all things can be done by youth so that more and more coverage of people can be done and legal aid and awareness and basic knowledge of law can be spread amongst the masses. I was a member of one of these initiatives and I worked for 1.5 years there. So I have learned that youth is very creative and it can change the dimension and the game of the dissemination of legal aid services as well as outreach programs of institutions if given proper recognition and opportunity. Now, the main role of legal aid, as pointed out by one of my previous speaker, was that it takes you to the reality of the society. It redefines the character and it redesigns the professional behavior because if you have worked for a few years in the society, you can never, never, ever be disrespectful for the clients who will come to you when you will be in advocate's chamber. You will not be disrespectful if you are a judicial officer and some person are sitting in front of you. And whatsoever profession you choose, your interpersonal skills will gradually improve and your professional behavior will also improve by institutional legal aid clinics. Lastly, the ways that are the way that is forward for institutional legal aid clinic is, first of all, effective methods have to be utilized. Innovative curriculum that should include in submission, just like we have to submit project and assignment, there should be something that you have to submit, either some poster or some content or some creative video or some informative nukkad script for the dissemination of legal awareness and for dissemination of legal aid clinic. Moreover, the student who will spend time on these things shall be incentivized not just by certificate, but some additional credits can be given to him in his coursework. A positive approach for legal aid is very much required because if you say that I work for a legal aid clinic, the students are not very surprised and they say go for rather a corporate internship. Why are doing internship or a work under a legal aid clinic or a legal aid authority? So that approach has to be changed. And lastly, the research and response to immediate things, like we have seen Project 39A of NLU Delhi. We have seen how NLS Bangalore is continuously involved in whatsoever emerging problem the people are facing. They are trying to reach them and help them out. Research is very much required that students can do. So these are the new dimensions where we need to explore the potential and the overall uh, usage and utilization of the students who are involved in institutional legal aid clinics. So I think that's very all. I'm open for the question and thank you so much for providing us this opportunity.
Thank you so much, Sir Sailesh Kumar Yadav, for your presentation. Now I would like to call another participant, Tarsaisas Gadzikwa and Prosper Mangazi, on the title, The Need for a Specific Approach Towards Justice Education.
Yes, good morning. Am I audible to everyone?
Yes, sir. Good morning. You're audible.
Yes, okay. Good morning to all the staff here and everyone else who's presenting. My name is Tasias Kadzikwa, and I wrote a paper with Prosper Mangezi from Gaugotias University. So, if possible, can I please be able to share my screen?
Yes, sir.
Okay. Okay, am I still audible to everyone? Am I audible?
Yes, sir.
Okay, I'm going to be presenting on the need for a specific approach towards justice education. Okay, so first we're going to deal with what is justice education. Justice education includes teaching people how our system of lawmaking and enforcement works, helping them to meet people who work in the justice system and building the basic skills that a person needs to manage the legal aspects of everyday problems. So basically, justice education is when we teach people who would normally not be concerned with legal education and trying to make them understand how the law works and who makes the law, which sector they need to approach when they get a certain problem, and all those matters related. So now, for better understanding, we're going to talk about what is the importance of justice education. Justice education is important to build a legally capable person who knows how to recognize legal issues and how and where to ask for help. It is also important to provide knowledge about the law and the legal system and to build skills for communication of perspectives of the general public and to ensure participation in the legal processes. It is also important to build confidence in the greater public and the justice system. So basically what we are saying is that justice education is an important aspect for the public, since it allows them to have a better understanding of how the law which governs them works. Moving on, we are going to talk about how it is implemented. It is implemented by allowing members of the public to meet lawyers and judges directly. But basically, this point is saying that one of the many ways of implementing justice education is by making the general public meet the people who make the law. Also, we can implement it by conducting conversations where the greater public can have open and honest discussions with the justice sector professionals. We can also implement it by making sure that the greater public is heard and treated respectfully by the law enforcement. We can also have it implemented by having the terms and processes of law explained to the public in a relaxed environment. Moving further on who can implement justice education. Justice education can be implemented by judges, lawyers, paralegals, police officers, law school students, and other justice sector professionals. Moving on to the heart of the presentation, the need for specific approaches towards justice education. The first need for a specific approach towards education is the evolution of time. In this point, we are saying that as the progression of time demands changes in various aspects of life and its proceedings, the same change has become imminent in implementation of justice education. Evolution of time introduces the need of specific approaches in justice education, because as time moves on, we get new concepts, we get new problems, and we get new lifestyles which come with their own challenges which need to be addressed by the law. So now, moving to the next point, globalization. Globalization also advocates for the need of specific approaches towards justice education. In globalization, the concept of open borders is the one which is advocated by globalization. So now the concept of open borders makes the older system of justice education, which dealt with closed boundaries, nearly obsolete, and as such, new legal components in relation to globalized legal system should thus be taught. Here, basically, what we are saying is that due to the change of globalization, which introduced open borders where people can freely trade and freely move around, new concepts of law have evolved, and as such, an advanced justice education should be implemented. Moving on, the popularization of cyberspace. The popularization of cyberspace also calls for revision and implementation of specific approaches towards justice education. The concept of a borderless cyber society is brought about numerous changes, be it in ordinary day-to-day life and also the legal systems, as seen by the numerous amendments being made to cater for cyber law in present law. Basically, here we're saying that the concept of cyberspace has seen various amendments, be it in IPC, in Evidence Act. Many amendments have been made to try to encompass cyberspace into the modern laws. So with all these amendments being implemented, this calls for a need for a revision or a change in the old justice education system. We need to get a new justice education system which caters for cyberspace and all of its implementations, and then we should make use of such system to spread awareness to the greater public. And also, evolution and growth of communities with a negative view on legal system is also advocates for a need for a specific approach towards justice education. In any society, be it in Africa, in Europe, in Asia, a certain community which has a negative view on legal system or on the laws being implemented is always available. No matter how good the laws are, some people would definitely have a negative view on the laws. So this community or this set of people cannot have the ordinary justice education be implemented to them, because they won't be open to any knowledge of the legal justice education, since they would already be having a negative view. So for such communities, it would be better if certain individuals who come from that community only are taught law and then sent back to advocate for what the law stands for and teach them justice education. Moving on to the next point, diversity and age differences. Diversity and age difference call upon for different approaches towards justice education. When dealing with people of a diverse nature, only one general system of justice education won't be enough to cater for everyone. So when dealing with diversity, we need to farm out people who belong to one beat, one caste, one religion, one race, and then try to implement a specific approach justice education system so as to better cater for everyone involved in that diverse group. Also, in relation to age differences, in modern day, people have tend to lean towards usage of the internet in new modern ways. So if we try to implement justice education in the old ways of classrooms or pen and paper, it won't directly affect them. So if we want to deal with the younger generation, we would need to implement other methods such as usage of the internet or social media platforms, be it YouTube, Instagram, and whatnot, to better connect with them. Also, this age difference, also we need to cater for the older generation. So we cannot completely remove the old pen and paper mode or the old direct mode of implementing justice education, hence the need for a specific approach towards justice education in dealing with different age groups. Another point which advocates for the need for a specific approach towards justice education is the natural disasters and pandemic. Recently, globally, we've been facing numerous natural disasters ranging from tsunamis to other natural hazards, and also over the past few years we were facing COVID. So all of these natural disasters and pandemics can have legal implications on them, like how people should address such matters in a legal way and how they can get help or how they can report whatever case is going on during such times. Hence, the need for specific justice education, which deals with natural disasters and or pandemics only. So basically, the traditional justice education should be revised to a point where it caters for single groups at single levels, specifically targeting a specific set of people so as to better implement justice education. Thank you.
Thank you so much, sir, for your participation and sharing your knowledge. Now, I would like to call another participant, Annie Cotonia, and her topic is reviewing theoretical approaches to clinical legal education. Annie Cotonia is here.
Who may proceed with the next one?
Ma'am, the participants are not here, ma'am. We have finished with all the presenters who were here. Two presenters are not here, ma'am.
We can now take up question and answers. Thank you so much for presenting, everyone. If anyone has any question or any comment for any of the presentations, you can type it out in the chat box. We'll wait for 2 minutes for all the questions.
As a participant, Annie Cotonia is here. I would like to call her to speak upon her topic, giving theoretical approaches to clinical legal education.
Just drop a message, Umaid, once.
Okay, ma'am.
Hello, thank you. I have some slides I would like to share, and if you can please give me the sharing rights.
Mahima?
Yes, ma'am.
Thank you. So my presentation is on reviewing theoretical and philosophical perspectives of clinical legal education. And well, I start off with introducing myself. My name is Anne Kotonia, and I am a clinical legal education researcher and advocate. I'm based in Nairobi, Kenya, at Strathmore Law School, where I teach labor law and financial services law. I have also worked in the university's clinic for quite some time, having set it up way back in 2013. So my own research is also on clinical legal education, and I carried out empirical research on clinical legal education in Kenya, just examining the extent to which the university law clinics in Kenya contribute to access to justice. And that entailed, of course, visiting university law clinics, examining the kinds of activities that they carried out, asking questions about how they were set up, and the ways in which those clinics operate. So, of course, with every research that one carries out, you need to have a certain theoretical treatment of that subject. What are the philosophical underpinnings of CLE? What are the theoretical underpinnings of CLE? So that is a process that really struck me, as it would strike any researcher, because the topics such as ours, which I think in a setting like this, majority of us work in clinical legal education activities, we tend to focus a lot on the practical. And so in my looking at literature, I came to realize that there's a lot of gaps in terms of theoretical approaches, for example, to clinical legal education. What theories inspire clinical practice in different kinds of clinics. So during this presentation, I thought of giving out a time frame that we have, but I'd like to throw out this question to you as a participant in this session. Take a pause and briefly examine what comes to mind in your own. We all came back into plenary and shared our ideas. We would likely emerge with definitions perhaps close to this one, which I picked out from the European Network for Clinical Legal Education website, as a legal teaching method on experiential learning, practical oriented, maybe other terms that we might encounter are student-centered, problem-based, interactive learning, practical skills. So that emphasis on practice, on experience is very loud. And so that's what drew my attention to the work that I'm currently carrying out, and snippets of which that overly question about the theoretical approaches and philosophical foundations, and basically theorizing the need to theorize more on our clinical practice. So to have done is to pick out literature. I'm building up on that work, and so what I share here is just snippets. And given the brief nature of the presentation, I've left out the specific authors and within own work that I'm writing, and that is a presentable stage. So far, things like this would build upon and would raise questions about. The most common one, of course, is a human rights approach. And then these spill out into different, they take different routes, if I may put it that way. There's the liberal approach on one side, and these approaches, when you consider access to justice using liberal human rights approaches, what emerges here is that human rights approaches, the duties towards access to justice is placed upon the state. So entities such as university law clinics, non-governmental organizations really do not have a duty towards human rights. Now, there are other human rights approaches, and these are more solidarity community approaches that are more open to non-state actors and persons who therefore use human rights approaches to justify their claiming work are relying more on solidarity community arguments. And there are others also that are more broader, still human rights, but they extend towards moral duties that you would accord to any human person, regardless of their nationality, their citizenship, their capacity. So you look at a human person just as a person, and then because you're a clinic and you have the knowledge and capacity, you extend your legal assistance towards them just because of that, not because you're required by any legislation or you're required, it's a duty incumbent upon you, but merely because of extending your understanding capacity towards a fellow human person. Are human rights approaches the only ones existing in our literature? They are not. There are multiple others, and I'm not presenting on all of them because I have not exhausted them in this particular presentation. But there are others I would like to pinpoint as I bring my presentation to a close. Interesting ones I have encountered. The first of these, funding of clinics in a country taken care of within the legal aid legislation. Their underfunding means that they are unable to provide justice towards people who have an unmet legal need. Another interesting idea I present as 7 is the proliferation of street law clinics, even in regions that neoliberalism is really prevalent. So when a neoliberal law curriculum often focuses more on the benefits of that curriculum towards the individual lawyer, towards the individual student, there is less emphasis on support to society. So you find that even if those law curriculums have a neoliberal approach, street law still exists within the curriculum and within those law schools. Why? Because it's street law facilitates offering of services to the society, but the focus is then placed towards employability. The students who actually participate in those programs are better prepared for the working world. And maybe employers will prefer these kinds of students because of the kind of experience they've encountered. Now, despite that neoliberal approach of the curriculum and the focus on the individual, you find that they are still able to have street law programs that operate in their societies. Although the emphasis is placed mostly on the benefit towards the student, but that doesn't mean the society doesn't benefit, because it does. I'll finish with the legal pluralism, because the paper I'm critiquing on Ethiopia shows how the Ethiopian legal system is quite pluralistic. So they have both formal and non-formal law operating within the same society. And law clinics therein make use of both perspectives to resolve disputes among clients that come to see them for dispute resolution purposes. I think the question of therapeutic jurisprudence and legal aid is also another interesting one, more so in the setting in which it's being utilized to examine disability rights clinics and how persons who make use of it with other challenges that then might prevent their access to justice. Apart from economic challenges, there might be those psychosocial or medical issues that present further boundaries towards their accessing justice. Hence, the therapeutic justice approach and suggestions being made to have both therapy and legal approaches utilized together. So I know that has really been very brief. I provide my email address here so that we could have further interactions with specific individuals within the session who have an interest in the topic and may have questions or contributions directly to the work that I've presented. Thank you so much for listening to me, and welcome your questions.
Thank you so much for your presentation, ma'am. Now, I would like to tell the presenters if they have any questions, please drop out in the comment in the chat box. As there are no further questions on clinical legal education, now I would like to conclude. And I would like to thank all the participants for their presentation and sharing knowledge to all my fellow friends. I would like to thank our session chair, Dr. Devinder Singh, for joining us today. And I would like to thank all the presenters.
Thank you very much, and every participant. And I hope I was there and throughout the time. And every presenter has made the best effort and shared their experiences in the all the institutions, the work being done on clinical education and legal aid and human rights. I congratulate the organizers, especially Niteshi, who has bring us all together in the form of international conference. So I think it's sufficient. And once again, congratulations. Thank you very much be a part of this. Thank you, Niteshi.
Thanks a lot, sir, for joining. I understand the network issue and crisis because of network. You really tried very hard to be part of us, and thanks a lot for joining. And your presence is always kind of guidance for us to do more work. Thank you, sir.
Thank you, Niteshi.
Thank you, sir. We'll begin the next session at its scheduled time. All of you can stay logged in.
Make around in how much time it is going to start?
It's scheduled at around 1, sir.
1. So there is a half an hour gap. Okay, fine.
More than half an hour.